Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching. We would look today in one of the key concepts of sanctions law, the concept of ownership. And more specifically, we would consider how the concept of ownership, which has its property law roots, is different in sanctions law. We would then briefly consider this concept in various jurisdictions and finish by trying to apply these legal principles to various practical scenarios in the context of different type of assets, and more specifically in the context of corporate structures, where the concept of property in sanctions law has its distinct features. Pausing here for a second. Originally, embargo type sanctions, which would prohibit complete trade in certain goods, for example, most typically in arms, or any kind of trade with a specific country or region, would have little recourse to the concept of property. Well, in essence, because the type of sanction is of such a nature that all type of relationship is prohibited, and there is no need to somehow distinguish between different types of transactions. When the sanctions regime started to move towards targeted sanctions, whereby they would restrict dealings with a specific individual or a company by imposing so-called targeted asset freezes, which in essence would freeze all assets of such person or company and would not allow to provide any additional assets to them, it became necessary to have some delineations of what those assets are. And we would see that in practical terms, it's not that easy to delineate those assets, because a person can have different types of rights, interests, and claims towards the assets. In the modern world, they can have different complex shapes and forms. Naturally, the starting point in that delineation was to use some known concepts to the jurisdictions, where the concept of ownership would be the most relevant ones, as in principle, to the extent the person owns an asset, meaning that has the broadest possible rights to dispose of the assets, to exercise other rights with respect to the assets. Such assets shall fall within the scope of the relevant restrictions coming from the blocking sanctions law. Nevertheless, it also became clear very soon that the simple import of the ownership concept, as it is defined in the property laws of various jurisdictions, would not be appropriate for the sanctions law for a number of reasons. First of all, the scope of sanctions law and the purpose of sanctions law is different. The need to ensure that no circumvention by way of careful legal structuring is achieved is one of those main purposes of sanctions law. And from that perspective, the legal concept of property may need to be expanded to achieve that purpose. It is also the point that ultimately in the European Union, for example, but also on a broader scale, when we think about multilateral sanctions imposed at the UN level, there is a certain need that the sanctions laws have a uniform interpretation and application. And from that perspective, just importing the concept of ownership, which would be distinct in each relevant jurisdiction, would not really achieve that uniformity of application. Accordingly, the practical matter is that whilst the concept of ownership and sanctions law starts with the relevant concept in the jurisdictions, it certainly has its own meaning, its own roots, and its own scope. The concept has the application in almost any jurisdiction, and here I give two typical examples of a blocking statute in the European Union, which in essence would apply to any asset which is belonging to own held. These three words will be covered by the concept of ownership or possession. And then those assets have to be blocked to the extent they fall within the jurisdiction of the relevant member states. The ownership is not limited to blocking sanctions only. The typical statute of imposing sectoral sanctions would again normally apply to specific entities listed in the sanctions statute, as well as, to the extent those provisions will be extended, companies owned by such entities. And here we have the example of statutory statute, which applies the sectoral sanctions to the Republic of Belarus and any public ownership entities which are also within those restrictions. Here is an example of the UK statute, which in essence is based on the same principle, whereby the ownership concept is used to define those assets which would be the scope of the blocking statute. In essence, the words are very similar, which we have just reviewed, which is not surprising given that in principle the United Kingdom is following the previous EU regime of sanctions, although there are some important distinctions which we'll discuss in a minute. Finally, the US sanctions regimes operate with the concept of property and interest in property. So the typical blocking statute will read as follows, that all property and interest in property of a designated person need to be blocked. And the OFAC 50% rule, in essence, says that any entity which is directly or indirectly owned by a designated person or a number of persons by 50% or more is deemed to be blocked in its own name, even if not directly listed, and all the assets of such an entity which fall within the US jurisdiction have to be blocked. And similar to the European Union or the UK, this rule applies both to the blocking sanctions and to the sectoral restrictions following from the US sectoral sanctions law. So in essence, as we can see in all major jurisdictions, the principle of ownership is one of the key factors, one of the key criteria, which is used to define the scope of the sanctions. And in principle, it operates in a way that all assets, all economic resources, all funds, all property or interest in property, to use the US terminology, of the blocked person have to be blocked. And that's the way the sanctions operate. They do not relate to the person as such, so they typically would not prohibit any kind of personal interaction with the person. The only notable exception from that will be the travel restrictions, travel bans. But apart from that, there is no restriction for personal interaction, except where those interaction are leading to the dealing in the assets, which have to be blocked. So from that perspective, it's important now to consider how this concept of property applies in practical terms. And here we can look at two situations. The first situation is when the blocked person has interests with respect to certain assets, which are not corporations, right? So we now discuss the situation outside of the corporate form, when a person, for example, owns a piece of real estate, has rights to a bank account, is a party to a contract, this type of situations. Meaning the situations where a separate legal person is not interposed between the relevant blocked person and the relevant asset. And when we look at these situations where, let's say, the bank account will be the most common practical example, then the concept of ownership covers any type of legal or equitable interest which a person may have with respect to that account. So whether the person is a legal owner of the account, whether the person has some equitable interest with respect to the account, whether there is any other type of property rights which are recognized by the laws of the relevant jurisdiction, it is very likely that this type of property interest will fall within the concept of ownership and sanctions law, and accordingly, to the extent a blocked person has this interest with respect to the asset, this asset has to be blocked. Nevertheless, it appears possible here to draw a broad distinction between property rights and mere contractual rights. So the rights to exercise certain powers and discretions with respect to the asset on the basis of a contract. For example, power of attorney would be one of those examples. Holding the office in the company would be another example. So here, it's clear that because a blocked person is, for example, the chief executive officer of the company, such person has no property rights with respect to the account of the company. And for that reason, assuming that the company itself is not blocked, the fact that the chief executive officer of such company is a blocked person shall not, in principle, trigger the application of the ownership criteria. So a broad distinction can be drawn between property type of interest, when any type of interest will suffice to block the property, and contractual type of interest, when the property criteria shall, in principle, not be engaged. A word of caution here, of course, that the other criteria which is applied to achieve the same purpose, to define the categories of assets which are subject to block, is the criteria of control. And in this sense, the contractual based rights are very likely to be caught by the control criteria, which we will discuss in a separate presentation. Assets held in joint tenancy are likely to be blocked in their entirety, because in principle, the blocked person has a property right over the entire asset. It would not be possible to split or divide the assets once the asset is blocked, because typically these operations will require an authorization of the relevant national competent authorities, because this would be classified as altering or dealing in the assets. So unless this authorization is issued, all property which is held on joint tenancy basis will need to be blocked. Conversely, with respect to the tenancy in common, that part of the asset which does not belong to a blocked person in principle shall not be blocked. And the good example here would be the omnibus accounts, where the security brokers or securities intermediaries have the client assets. So assuming that as typically the jurisdictions would recognize some sort, at least, of property rights of the clients of these institutions with respect to those assets, the fact that the financial institutions have a blocked person as one of their clients would not typically result in the whole pool of assets being subject to be blocked, because those rights will not be based on the joint tenancy concept. Needless to say, applying the same criteria to this example, but now assuming that the intermediary institution itself is subject to be blocked, most likely this will result in the block of also clients' accounts of such institution, because although the clients of the institution would have the equitable rights with respect to those assets, the institution itself will also have the legal rights to the assets, or at least some sort of property rights in the relevant jurisdictions, and accordingly, on this basis, although holding those assets on behalf of these clients, most likely the assets would be blocked because of the interest of the institution itself subject to the blocking sanctions. Next point is to consider the same concept, but in the corporate structures. And that's, I think, is the main example of how the concept of ownership in sanctions law is different from the same concept in property or companies law, because in principle, the concept disregards the separate legal personality of those companies where a blocked person has a qualifying shareholding in the capital. The standard position would be that all the assets of the company are the assets of the company itself, and the shareholders of the company have no claim to those assets and have no rights to dispose of those assets. It's the managers of the company who are dealing with these assets on behalf of the company. This would be the core of separate legal personality concept, which is known to any jurisdiction in the modern world. So typically, if we look at the property relationship from the company or property law perspective, the only assets of the shareholder will be the shares themselves. And it goes without saying that those shares, to the extent they are located within the jurisdiction imposing blocking sanctions, would need to be blocked and could not be disposed without the consent of the relevant national competent authorities. Nevertheless, almost any sanctions regime recognizes that the property would be extended also to the assets of such company to the extent the relevant shareholder has more than 50%. There is a certain unclarity whether the assets are subject to the right of so-called indirect ownership or control, and those terms are issued interminglingly in different jurisdictions. But at least with respect to the US, where the position is that the extension is based on the ownership rights and not control rights, it seems to be clear that the general view is that, at least with respect to the shareholding, we talk here about the ownership concept in sanctions law. So what is this qualifying threshold? In the US, it's 50% of the share capital. Same in the UK, it's more than 50%. The general approach in the European Union, which is based on the definition of what owning legal person is, given the Council Regulation 2580 of 2001, is that 50% threshold is the relevant threshold. The threshold applies regardless of the number of companies in the chain, and to the extent at any level the threshold is less than 50%, the chain is broken, meaning that the concept of ownership doesn't look through the relevant company, and the relevant shareholding will not be aggregated to the extent the aggregation rules apply. Aggregation rules mean that if several block persons have shareholding of less than 50% in the relevant company, but jointly exceed this threshold, then the jurisdictions like the United States and the European Union will consider the company to be blocked. In the UK, the aggregation rule doesn't apply, which frankly, from the pure legal perspective, seems to be a better view, because to the extent those two persons are not coordinating their efforts, then none of them really owns the company. And to the extent they coordinate the efforts, then we talk more about the control over the company, which they jointly exercise, and so different criteria have been applicable rather than ownership itself. But as I said, there is certainly a degree of artificial approach from the legal perspective in terms of defining where we really cross the borderline between ownership and control, and which exactly criteria applies. And in those jurisdictions where both criteria work, these concepts will be typically used jointly without paying too much attention as to whether we're exactly within the ownership area or within the control area. An important question to consider here is what assets need to be owned. It's clear that the capital of the company is always captured. So to the extent we have multiple shares, we'll talk about the aggregate of those shares. Then in some jurisdictions, there is a separate provision for voting rights to the extent they will be separate from the aggregate capital. It seems that unlikely that any kind of debt instruments will trigger the ownership criteria, since they typically represent no property rights with respect to the relevant corporations. Final point to note is a question of divestment. And the question is, to which extent the divestment post-designation of the blocking person can disrupt, can cut the ownership link with the relevant company. The position in the US is that to the extent the divestment occurs outside of the US jurisdiction, the divestment will cut the relevant link, but it will not cut it all the way through the assets blocked in the US, which once blocked remain blocked unless OFAC issues the relevant authorizations. In the European Union, the exact position is not clear. And it seems that a better view would be that to the extent the ownership link is efficiently cut and the ownership passes to the non-blocked person, and there is no risk that the relevant assets would be provided to a blocked person, then the property of the relevant company within the European Union shall not be deemed to be blocked. I trust that you found this presentation useful, and thank you very much for watching.